Seconds to go. Start. A police officer has to resort to Section 91 CRPC to mandate the provision of any document. Hence, Section 91 CRPC cannot be equated with the powers under Section 50 of PMLA. Section 160 CRPC applies to a police officer who is making an investigation under Chapter 12 of CRPC, whereas the process envisaged by Section 50 of PMLA is in the nature of an inquiry and is not an investigation in the strict sense of the term, as held in case of Vijay Madan Lal Supra. ED has the power to summon any person whose attendance is considered necessary, whether to give evidence or to produce any record as contemplated in Section 50 of the PMLA. A statement made under Section 50 is admissible in evidence, whereas the statement made under Section 161 is inadmissible as provided under Section 162 CRPC. There are stark inconsistencies between Section 50 PMLA and Section 160 CRPC, and therefore Section 160 CRPC would not apply to the proceedings under Section 50 of PMLA. The procedure to exercise power under Section 50 PMLA is laid down in the rules called the Prevention of Money Laundering Forms, Search and Seizure or Freezing, and the manner of forwarding the reasons and material to the adjudicating authority, impounding and custody of records, and the period of retention rules 2005. The appellant number 1 had attempted to mislead the court by suppressing the fact that he had residence in New Delhi also. The statement made under Section 50 of PMLA would not infringe any fundamental right of the person contained in Article 23, inasmuch as the person making the statement is not an accused at the time when the statement under Section 50 is recorded. As regards territorial jurisdiction, it is submitted in the alternative that as per the case of ED, the proceeds of crime to the tune of Rs 168 crores were transferred through vouchers to Delhi and overseas, and therefore there was adequate nexus with the territory of Delhi with the alleged offence. Even a prosecution complaint could have been filed in Delhi, which would be consistent with the law laid down by this court in Rana Ayub versus Directorate of Enforcement. The regional offices created in the Directorate of Enforcement are for administrative convenience and do not in any manner limit the scope of inquiry of those concerned offices or officers if the offence of money laundering spreads over multiple states. Section 5 read with Section 4.2 of CRPC itself contemplates that nothing contained in the Code of 1973 would apply or affect any special law in force regulating the manner of place of investigation, inquiring into or dealing with such special offences. There was no illegality in summoning the appellant number 2 to New Delhi, as according to the ED, the proceeds of crime had travelled to New Delhi, which would be the area in which part of the offence has been allegedly committed. Section 50 of PMLA is gender neutral as it does not make any distinction between a man and a woman. The court cannot carve out an exception in favor of women in Section 50 when there is none. Whenever the legislature felt the need to carve out an exception in favor of women, it has done so, as evident from the proviso to Section 45 of PMLA. Therefore, there cannot be any presumption that a casus omissus exists in Section 50. stop.